All right. Good evening, everybody. My name is Samuel Berkson. I'm an attorney with Gubits and Gubits. This is our January 11th presentation of Landlord and Tenant Proceedings in New York State and the impact of COVID-19. I think this is a very pertinent and important discussion and webinar that we're having today, just in relation to the housing crisis that's going on. I'm going to be providing a lot of important information to landlords and tenants as we go through the webinar. Don't hesitate to ask me any questions you'd like. I could try and answer them while I'm going, but I'll probably save the questions, the question and answer session until the end. And you're also entitled, by viewing this webinar, to a free 15-minute consultation. So call the firm at any point, in the next couple of weeks. You can ask for Valerie Gross. You can ask for myself. But as long as you mention that you were a participant in this webinar, you are entitled to a free 15-minute consultation call. So please take advantage of that. Now, very quickly about Gubits and Gubits. We're a full-size, full-service law firm in Walden and Monticello. We serve the Hudson Valley area. We've served the Hudson Valley area for over 50 years. We're a firm of over 20 attorneys and full support staff. We concentrate in over 30 areas of law, including bankruptcy, business, estate planning, environmental, equine, land use, municipal, personal injury, planning and zoning, real estate, real property tax, and really any field of law that you might have an issue, we can probably handle that for you. So please reach out if you have any legal disputes, not just landlord-tenant issues. Meetings we do in the office by appointment. We also can do virtual meetings via Zoom, FaceTime, Skype. Any means that you feel comfortable, we can probably meet with you. I personally, I'm an associate attorney. I concentrate in land use, municipal law, real estate, and of course, landlord-tenant disputes. Jumping right into it. Evictions in New York are categorized as summary proceedings. A summary proceeding is an expedited process through which a landlord may evict a tenant. These are justice court proceedings that take place before a local judge in a town or village court. Summary proceedings, being a statutory creation and not a common law right, must comply precisely with the statutory requirements. Otherwise, a dismissal of the proceeding on jurisdictional grounds might result. What that means, legal translation, is that you need to follow the rules. If you don't follow the rules to a T when you're conducting an eviction proceeding, the judge can and will likely throw out the case. That means you'll have to start all over, pay the fines for filing, pay the service fees, and restart the whole process if you don't follow the entirety of the rules for a summary proceeding. And evictions in New York are very complex. Landlords need to navigate an increasingly complex web of rules and regulations surrounding landlord-tenant proceedings in New York. Otherwise, cases will get dismissed. It's an extremely Byzantine system. There are a lot of rules, like I just said, and if you don't follow them, the case will get dismissed. Landlord-tenant relationships and evictions in New York are generally governed by Real Property Law Article 7 and Real Property Actions and Proceedings Law Article 7. That's just for a reference. And so how does someone who's entitled to possession bring a summary proceeding? So what people are entitled to bring a summary proceeding, right? Of course, a landlord, if you own a property and you're renting it out, you're the landlord, you're entitled to bring a summary proceeding. A purchaser at a foreclosure sale, someone who might buy a property via tax foreclosure, they're entitled to use a summary proceeding process to use whoever might be staying in that home or apartment. And a lessee entitled to possession, or any other individuals who are entitled to possession of a property, they're entitled to use the justice courts to evict the tenant. At a minimum, the following papers will be needed to be served by the landlord on the tenant and then filed with the court. So you're going to need preliminary notice, which is either going to be a notice of termination or a notice of non-payment. You're going to need the notice of petition, and you're going to need the petition. I'm going to get more in depth on those documents later on, but really the preliminary notice, that gets sent out to tell the tenant that the landlord is initiating the action. The notice of petition, that tells the tenant the location of the court and the time that they might need to appear. And the petition itself is going to lay out all the factual allegations why the landlord is entitled to take possession to the property. And so, what are the grounds for an eviction in New York? The first thing you need to address is who can be evicted. A tenant includes an occupant of one or more rooms in a rooming house or a resident, not including a transient occupant of one or more rooms in a hotel who has been in possession for 30 consecutive days or longer. No tenant or lawful occupant of a dwelling or housing accommodation shall be removed from possession except in a special proceeding. So 30 days is very important. That's the operative amount of time. And you have to be aware that once someone stays in the premises for 30 days or longer, they're going to gain the rights of a tenant. Whether or not they have a lease, whether or not you acknowledge them as being your tenant, that person, that individual, if you're living and renting an apartment, if you're living somewhere, once you get 30 days, once you've hit 30 days in that spot, the landlord can't call the police and say you're a trespasser. The landlord is going to need to bring you out of that property via an eviction. He's going to need to get a warrant signed by a sheriff. So 30 days is key. For landlords and tenants, you need to remember that 30 days. We'll discuss the following summary proceedings in more depth later on. So you have your non-payment proceedings where a tenant might not have been paying what they owe to the landlord as per the lease. You can have holdovers, and that's a situation where the tenant's remaining in the premises after the terms of the lease have expired or without any lease agreement. You can have a breach of a lease where the tenant has breached some sort of terms of that lease agreement. And then you have also, there are grounds where no landlord-tenant relationship exists. And I'm going to quickly address that as well. And so I'm going to get into all those different landlord-tenant proceedings later on. But right now, I think more pertinent, I'd like to address what the impact of COVID-19 has had on landlord-tenant proceedings in New York State. And so before I address this slide, there have been a lot of different executive orders, laws, federally, state mandated, and administrative orders that have come down by the state, by the governor's office, and by the federal government in trying to address the COVID-19 impact and how much of an impact it's had on housing in the country and in the state. And so right now, I'm going to address the administrative orders because the state is really operating under the guise of the most recent administrative order. And so a quick background, when the pandemic first began back in March, on March 16th, the Unified Court System for the state of New York issued a memorandum suspending all evictions. And so in March, they issued a blanket suspension on evictions. That lasted for several months. In October, the chief administrative judge issued an order that evictions might resume with certain caveats. Extra notices were required, and then all matters commenced before March 17th had to be conferenced. And so cases were allowed to resume in October, but there have been a lot more layers that have been added by the governor's office and by the legislature in New York, things that must be done by a landlord in order to fully bring a case to evict the tenant. And so I'll get into that as we get into the recent administrative order, which was recently issued on December 30th. So this was 2 weeks ago. The administrative order was issued to advise, amongst other things, that any residential eviction proceeding filed before January 27th, 2021 is subject to a 60-day stay. Okay, so what does that mean? It means essentially any cases that have been filed or any cases that will be filed up to January 27th are now subject to a 60-day stay. The judge is not going to be able to take any action in those cases for 60 days. And so administrative order did put cases on hold at the moment. I am in constant contact with justice courts in the county. Some counties, some justice courts are hearing cases. A lot of justice courts are not at the moment. And so you can reach out to the justice courts and see if they will accept your petition for filing if you're a landlord. Most justice courts will not. If they do, you might be able to get an initial hearing, but the judge is not going to be able to take any action at that initial hearing based on the administrative order. Some other provisions that are very important that came down with the administrative order just recently: default judgments. If the tenant does not appear, then the judge is not going to be able to execute that warrant until May 1st. So that's a few months from now. So if you do get a court appearance and the tenant doesn't appear after being properly noticed, the judge typically would enter a default that day and sign and execute a warrant, or sign a warrant to be executed by the sheriff. But now the judge needs to wait until May 1st. Another caveat that recently came down from the administrative order: if you had gotten a warrant that was previously signed by a judge, that judge now needs to conference the case again. So cases that you might have thought as a landlord were resolved, or as a tenant you might have thought, you're just waiting for the warrant to get executed, those cases now technically need to be brought back into court for a quick conference. Also, there are more requirements in terms of the notices that need to be sent. Hardship declarations are required to be sent as a landlord to all of your tenants. Now, I said that there's a 60-day stay on evictions. So that takes us out until about March 1st. If the tenant signs a hardship declaration and submits that to the landlord, the tenant is then going to essentially get another 2 months and cannot be evicted until May 1st. And so what happened was the administrative order automatically stayed cases until March 1st. But upon the submission of the proper papers by the tenant, that stay can be extended for specific cases until May 1st. None of this applies to a nuisance situation. So if a tenant is causing a nuisance or creating issues that might impinge on impugn on the safety and health of other tenants or of your property as a landlord, then you can still take the case to court, and the rules I just outlined as per the most recent administrative order won't apply. Just for reference, if you want to look online, that administrative order is AO/340/20. And if you just type that into Google, you'll be able to pull it up. It's a 4-page order, and you can review all the details that I just laid out. Now, next, I'm going to cover the executive orders, which were for a long time the controlling rules regarding eviction proceedings. Over the course of the last year, the governor has issued about 80 to 90 executive orders built off the original executive order 202.1. And so these executive orders have been coming, you're getting 1 or 2 a week, and many of them have impacted landlord tenant proceedings. Early on, executive order 202.8 coincided with the administrative orders issued from the courts that stayed all evictions. Looking more recently, I'll bring your attention to executive order 202.85, which continued the prohibition on the execution of warrants, just like as I outlined from the recent administrative order. That goes through January 26, 2021. And so the administrative order that recently came down, that supersedes the executive orders right now. So while the executive order 202.85 prevents any execution of a warrant through January 26th, the administrative order goes past that to March 1st and to possibly even May 1st. And so right now, while the executive orders they previously had more significance, right now they aren't as significant as the administrative order and some of the legislation that has come down. And so I'm moving on you can see this slide. I'm highlighting the state legislation that has come down to address the housing crisis that's been a result of the COVID-19 pandemic. And so in June 30th, the Tenant Safe Harbor Act was signed into law, which provides an additional defense for tenants facing an eviction for non-payment if they prove financial hardship during the covered period, which is from March 7th through whatever date the executive orders would no longer be effective. Now, on December 28th, 2020, the COVID-19 Emergency Eviction and Foreclosure Prevention Act was passed, which put a stay on all residential evictions for 60 days and until May 1st, just like what stated in the administrative order. And so the things I laid out 2 slides ago in the administrative order, those are predicated on the terms of the law that was passed, recently in the end of December. And so those overlap, right? Now, the one thing that I will explain is that the hardship, the financial hardship that you were allowed to use as a defense in a landlord tenant proceeding from the Tenant Safe Harbor Act has been carried over into the COVID-19 Emergency Eviction and Foreclosure Prevention Act. And so the covered persons from the Tenant Safe Harbor Act, those are individuals who have been attempting to make payments. They've been attempting to find employment. They've been attempting to find funding to make payments to the landlord. And importantly, for single individuals, that's individuals making under $99,000 a year, or for a family or a couple, it's under $198,000 a year. And so if you fall under the covered persons category, then you will be able to submit a hardship declaration and use that as a defense in an eviction proceeding, which the judge is going to use to potentially give you more time before you're evicted. And so if you need any more, if you think you might be as a landlord, your tenant might be a covered person, or as a tenant, you might fall under that provision of a covered person, and you might get the protection that's been outlined by the state, definitely reach out. Definitely reach out to me for a consultation and to see if, as a landlord, what your rights are, and similarly as a tenant, what your rights are under the situation that you might be in. So don't hesitate to please reach out. Moving on, I do want to quickly address the federal legislation that's been passed. CDC Moratorium on Evictions is effective through January 31st, 2020. It covers non-payments and does not cover holdovers or breaches of a lease. The order provides a defense for covered persons. I just went over that in a landlord tenant proceeding. The order will not stop the landlord from starting the proceeding. And for a tenant to take advantage, they need to sign off on a written declaration attesting under penalty of perjury to those important facts that I just outlined a second ago. Now, it's important to also recognize that the administrative orders in New York and the state legislation that's been passed does supersede the CDC moratorium at this point, as that moratorium is only effective through January 31st. The administrative orders and the legislation in New York extends protections to tenants through March 1st at this time. And so, there's really not too much impact that the CDC moratorium does have. It could potentially get extended. I'm not sure if that would be the case, but it could. Right now, however, the administrative orders in New York, the administrative order and the new legislation, those really take more prominent effect on the summary proceedings. And so, just generally, before I move on and move away from the impact that COVID has had, I think it's important to make it clear that there's still a lot of uncertainty going on in terms of what the next steps are going to be. I think the state has tried to create some direction with this recent administrative order, giving an idea of what the nature of the proceedings will be for the next several months. One thing I might have missed, and I do think it's important to mention, is that at this point, all proceedings are virtual. All hearings and conferences at the justice court level, regarding landlord tenant matters, are virtual. So if you are able to get a hearing set in the next few weeks, that would be heard virtually. And so I have done myself several virtual appearances. Most of the judges do have that capability. Some courts don't. Some courts can't even hear they don't have the virtual capability to hear a case. And you're at, as a landlord, you're at the whims of the court, really, in terms of when you can get a hearing date. So that's something to keep in mind. But going forward, it's very important. If you're a landlord, you need to make sure you have the proper notices, the hardship declaration, all that paperwork needs to get sent to your tenant if you plan on initiating a summary proceeding. At the same time, as a tenant, you should be keep in mind that if you find yourself in a situation where your landlord might be trying to pursue an eviction against you, that landlord needs to make sure he has all his ducks in a row. He or she needs to make sure they have provided you all the proper documentation in accordance with the recent administrative orders and the legislation. And that's all on top of the laws that already existed and the requirements that already existed for landlords in bringing a summary proceeding. And so, like I said early on, you need to navigate an increasingly complex set of rules as a landlord to bring an eviction proceeding. And so these are even more rules that add more complexity to what's required of you. And so there really is a lot going on. And again, if you're a landlord, if you're a tenant, I'm going to advise you, don't hesitate to reach out. You're entitled to a free consultation, and I could very quickly address some of the more basic points and issues that you might have. And so, going forward, it's very important to make sure that all these steps are taken properly. I do want to mention one thing on security deposits. Tenants who are facing hardship may elect to have any security deposit held by a landlord applied to overdue rental payments. This is going back to Executive Order 202.28. If they do so, the following conditions apply. The agreement to use a security deposit must be in writing. The tenant must replenish the deposit at a rate of 1/12 the amount used per month. The agreement must cover the entire amount due. Otherwise, the remaining amount due is waived, and the repayment shall not become due until 90 days after the security deposit is used for rent. So what does this mean? If you have a security deposit that's just sitting in a bank account as a tenant, you can elect, it's your decision. You can tell the landlord, use that to use that security deposit to pay off rent. That landlord could then ask you to replenish the security deposit, but he can't go after you for a rental payment that security deposit might have been applied to. So that's something that's been in place for several months now. If you have questions on that, let me know. And then just kind of to wrap up the issue of COVID-19 and the impact that it's had on landlord tenant proceedings. It's been a very stressful year. I think all of us can acknowledge that. And I think, there's a lot of sympathy for tenants who are going through unquestionable hardship at this point, but there's also a lot of difficulty that landlords are going through in terms of making mortgage payments and, continuing with a positive relationship between their tenants. And so suggestions that I've had for landlords and tenants throughout the past few months have been to continue to talk to each other. Tenants who have been impacted by a hardship due to the pandemic, they should also let their landlords know. Communication is often very important in keeping these relationships to be positive. A breakdown in communication often leads to court, and sometimes these situations can be avoided. Nothing right now is currently preventing landlords from sending out the necessary predicate notices and having to pay for filing. So that's the step that, if you're a landlord, you can get notices sent out. There's nothing that's holding you back from doing that. And then also, tenants need to be aware that all these moratoriums on any evictions does not eliminate the need for them and the requirement for them to pay the obligations under a lease agreement or whatever amounts that were due for staying in the property. They're still going to be due and owed to the landlord. The lease is a contract agreement. If you don't make those payments, you're breaching a contract agreement. Those amounts owed are going to still be due to the landlord, even if they haven't been successful in trying to bring an eviction maybe for several months. So keep those things in mind as we go forward, and we continue to deal with the pressures and the stress that COVID-19 has placed on all of us. And so I'm going to move forward. I see I have a question. I'm going to address, I see this question. I'm going to address it. Give me a little bit. Let me address it because it is going to require let me look at this. I'll answer it at the end. I just want to keep flowing right now. And so as I get away from the impact that COVID has, I'm going to spend a little bit of time talking just about the basics of the different types of landlord tenant proceedings in New York State. And so first, of course, there's non-payment proceedings. That's a situation where if you have a lease agreement, between a landlord and a tenant, non-payment proceedings are summary proceedings that may be initiated by a landlord against a tenant who does not pay the agreed upon rent. It's going to require 2 predicate notices. First, you need a 5-day notice. That's going to have to go to the tenant if they haven't paid after 5 days of that payment being due. The landlord must send them a 5-day notice letting them know that that payment hasn't been received. After that notice goes out, the landlord can then send the 14-day notice of non-payment. When that 14-day notice expires, that landlord is then entitled to bring an action to evict that tenant. A very important thing to take note of for non-payment proceedings, they can be cured at any time up until the sheriff executes the warrant. And up until that tenant is evicted, they can come and pay the landlord the money that's owed, the rent owed, and that will dismiss the action entirely. And so a landlord might go through the process of, extending legal fees to bring an eviction. They get everything they want. They get a judgment. They get a warrant signed by the judge. The sheriff has the warrant in hand. The sheriff is prepared to execute the warrant on X date. But the day before the sheriff executes that warrant, the tenant comes and pays the landlord everything that's owed. The tenant cannot evict that landlord. The landlord cannot evict that tenant. The sheriff cannot evict that tenant. The tenant has effectively gotten that case dismissed. If they don't pay in the future, or there's some other grounds to bring an eviction, the landlord has to start the process all over. That's a non-payment proceeding. Holdover proceedings are summary proceedings that may be initiated by a landlord against a tenant who remains in possession of the premises after the expiration of the lease term, or if there never was a lease term, if there never was a lease agreement. And so this requires either a 30, 60, or 90-day notice, depending on the length of the term. If the tenant has been in the property for less than 1 year, 30-day notice is required. If the tenant's been in the property between 1 and 2 years, 60 days. If the tenant has been in the property for over 2 years, or the lease is for a term that's over 2 years, 90-day notice is required. Very important to keep those in mind. Those notice requirements are important. If you don't follow that notice requirement, the case could get dismissed. It likely will. Now, it's also important to note that when you serve these papers, the notice of petition and the petition must be filed between 10 and 17 days before the court appearance. It's very complicated in terms of how to go about, how to meet those dates. That's why I do suggest, if you're bringing a holdover proceeding, reach out to me, not just for a consultation, but to make sure that you follow all the guidelines. It does make sense to retain an attorney as a landlord if you're pursuing a holdover eviction. So filing requirements are very important. For a non-payment, you only have to get that petition filed at least 10 days before the court hearing. For a holdover, you have a 7-day period between 10 and 17 days before the court appearance where you have to file the papers properly. It's actually very complicated to get that done. Now I'm going to quickly address breach of a lease. That's where you have a summary proceeding for a violation of the lease. It will require 2 notices. First, a notice to cure. This is typically a 10-day notice, It advises a tenant of the breach and gives them a chance to correct any breach. And then you're going to have a notice of termination. That's a 30-day notice. If the violation has not been corrected by the tenant, this notice goes to that tenant and says the landlord is going to initiate eviction proceedings because you never cured that breach. The specific timeframes, 10 and 30 days, that's not always the case. Those timeframes are going to be specifically laid out in the lease. They should be. If they're not, I would suggest 10 and 30 days. That's typically what's used. But the timeframe should be laid out in the lease. A good lease will advise a tenant and a landlord of the notice to cure and notice to terminate time periods. And then also, the time for filing a petition is just like a holdover when you have a breach of lease. It has to be done within 10 and 17 days. So again, it's complicated and it needs to be done properly, but it's something that, you know, you can reach out to me, I can assist with, or I can handle if that's a situation that you think you're dealing with. The last situation that I'm going to quickly go over are grounds for an eviction where no landlord-tenant relationship exists. This only requires a 10-day notice to quit before bringing a summary proceeding. The typical situation here is when you have squatters, maybe a holdover post-foreclosure sale, or a licensee whose license has expired or been revoked. That's when you're going to use only a 10-day notice. So typically you have squatters, right? That's where squatters, most people are familiar with the idea of what squatters are. If someone's been in the property for less than 30 days, they never got permission, they maybe illegally entered and remained in the premises, you can attempt to get them out as trespassers. See, maybe the cops might remove them. But if the cops defer to it as a civil matter, you're going to need to send the 10-day notice to quit, and you will need to bring a summary proceeding sometimes to remove squatters from your property. And so before I go into this next slide, I just want to summarize. You have the non-payment proceeding, you have holdover proceedings, you have a breach of lease proceeding, and then you also have situations where there's no landlord-tenant relationship. Summary proceeding and all those different situations are going to have different requirements, and you are going to have to follow the different rules based on what type of proceeding you want to bring. And so just be cognizant of that. If you have any questions, don't hesitate to reach out to me. I can assist you at any point. Now, how does a tenant respond to a summary proceeding? Right? So you're a tenant, you're renting a property from a landlord, and the landlord initiates a proceeding against you, right? What papers will a tenant need to file? The tenant may, but does not need to file a paper answer. The tenant will need to appear at the courthouse on the date and time indicated on the notice of petition, but the tenant can appear in court and serve their answer orally. I'll be honest with you, in a couple of years that I've been working on landlord-tenant matters, I think only one time I've seen a written answer from a tenant. I've probably had over 100 times where I've had a tenant appear in court and just orally answer the petition. And so the tenant, typically you think of an answer in a legal proceeding as being a paper answer that's filed with the court. That's not the case here. The tenant is going to have the opportunity to appear and answer the petition. What are the common, most successful defenses to an eviction proceeding as a tenant? If it's a non-payment, the tenant can raise a defense that they paid the rent. Like I explained, if the tenant pays the rent, that will dismiss the action entirely. The landlord might have also failed to follow some specific notice requirements. If that's the case, because the landlord needs to follow everything perfectly, all the rules perfectly, in bringing an eviction proceeding, if a tenant raises a mistake or a situation where the landlord didn't follow the specific rules, then that tenant's going to have a defense that'll get the action entirely dismissed. And then also there's the question of the warrant of habitability. If the landlord is creating a situation where certain things that are necessary for a tenant to live comfortably, like the heat, water, certain other safety issues, if the landlord has breached the warrant of habitability, then the tenant can raise that as a defense that would prevent the landlord from being allowed to evict that tenant. And so that, I've gone over the impact that COVID has had. I've gone over the basics of landlord tenant proceedings and then the different types of landlord tenant proceedings. I do want to go over some changes that were enacted in the law for landlord tenant proceedings. This is the Housing Stability and Tenant Protection Act of 2019. The law created wide-scale changes in eviction proceedings. And so it's very important. I'm going to go over a few of the more important aspects of the law, but it's very important if you're online and you're doing some searching for eviction laws in New York, it's quite possible that you're going to find some outdated information because these changes went into place in the summer of 2019, which is not that long ago. And a lot of online blogs and legal advisement and articles and postings are in relation to the old laws. And a lot of those old laws in terms of time, notice requirements and petition filing requirements, those time periods have changed. And because you need to follow the rules in New York for landlord tenant proceedings so precisely, the fact that those laws have changed could impact you if you find some incorrect information online. And so I caution you to that. And then, on that note, I'll segue into some of the more relevant provisions from the recent law. First, a 14-day adjournment is required if the tenant requests it at the initial hearing. And so you can get your tenant into court, but at that first hearing, the tenant can come in and ask the court for 14 days of an adjournment, and the court is mandated to grant that adjournment request. The court has no choice. The court has to give the tenant a second hearing. And the reason for that is so that they can get an attorney or review the petition, but really it just creates an extra layer of time that the landlord needs to be aware of before they might be able to remove a tenant. Another thing that's very important is that only fees for use and occupancy can be requested by the landlord in a summary proceeding. Use and occupancy is the cost of living, right? The rent. The landlord is not going to be able to ask for attorney's fees, for damages to the property, for late fees, or for any other fees that might have been, owed to the landlord based on the terms of the lease. They can only ask for the specific rent payments in the summary proceeding to evict. So if you're a landlord and you're interested in getting getting a money judgment for damages, late fees, and attorney's fees, you're going to have to bring that in a separate action. You're going to have to bring that request in a separate action. Now, another provision is that warrants, they used to be able to be served on the tenant, and they used to be able to be effected by the sheriff in 3 days. Now, the sheriff needs to wait at least 14 days after the order is entered by the judge. And finally, the court has discretion now to issue a 1-year stay of an execution of a warrant. I've never seen this happen, never, but in the past 2 years. But if a judge finds justification, a hardship grounds where they really feel that the tenant should be allowed some further time before they need to leave, the judge is allowed to grant up to a 1-year stay of that warrant. Again, I've never seen that happen where a judge has really extended a stay of a warrant. And so that's it. I've covered a lot of bases, and I'm glad that I did because, again, it's a very important time in the state and in the country in terms of housing. I'm going to answer a couple of questions now, so let me go through. Let me answer a couple of questions. As I do that, you can see my contact information is posted. I will reiterate, as it says, that you're all entitled to a webinar, a consultation for everyone who's viewed the webinar, a 15-minute consultation. So call the firm, email me, reach out if you want to take advantage of that webinar. And then I'll also say, keep an eye on this space because Jacobowitz and Gubits, we do other webinars on other topics as well, estate planning, personal injury, we do matrimonial and stuff. So keep an eye out for other possible webinars that we might have down the pike. And so I'm going to quickly address a couple of these questions that I see. The first question I have, there appears to be 2 separate eligibility options a tenant can select on a COVID hardship declaration. You mentioned financial hardship, but there's also to select an option of health risk of displacement due to disability. Is there a requirement for the tenant to prove the details of what they're claiming to the court? Now, I'll say there is a requirement that the tenant is going to have to prove hardship. In terms of a disability or financial hardship, I'll be honest, the judges I don't think are going to push too hard on a tenant who claims hardship. I personally, so far, have not experienced that where I've had a tenant claim hardship and I've represented a landlord that wanted to challenge that. And I haven't heard anecdotally that any landlord's attorneys have had that issue. However, I know that if that issue is raised, the judge is going to be most likely sympathetic to the tenant, and it would have to be very clear that that tenant is improperly alleging a hardship. I hope that answers that question. Next one, in the case where a second court date for an eviction proceeding is past the initial 60-day stay, but prior to May 1st, and the tenant has provided a COVID hardship declaration, is there a benefit to obtaining a judgment without a warrant before the 60-day stay? Or would there be no benefit compared to another stay followed by a simultaneous judgment and warrant occurring on a future date? Well, so I think the question obviates the fact that it's been extremely complex now in terms of all the orders that have been passed down. My answer would be, give me a call. Give me a call and let's do a consult call. I think that would be the best forum to answer that question, because I think there are other facts that might need to be addressed. I have suggested to certain, landlords, if the money owed by the tenant is getting really, is really getting up there, you can bring an action for a money judgment. There's nothing that prevents you now from doing that. And so that's something that can be done. Again, if that's something you're interested in, it's a separate proceeding. Reach out to the firm. You can let me know. Are weekends and or holidays counted in the 10 and 17-day servings? Yes. Weekends and holidays are counted when you're counting the days on a notice. I'm going to go over to the chat here. I'm going to read. I got another question, Diane. How does the landlord collect rent for the past year? Basically, if they have not been able to pay to date, if the landlords do 10, 12, 13 months rent, when is the tenant required to pay? The tenant has to pay rent now. The tenant has been required to pay rent. If the tenant hasn't been paying rent, they've been missing those payments. They don't have, they're not given extra time now to pay these rental fees. Now, the executive orders have limited the late fees that landlords can collect, but if the landlord hasn't paid for 12 months and they're owing you 5 figures, and it's just, that money is getting, really, really high, you can bring an action for a money judgment against them. No matter what, whether or not you get a money judgment through an action just for that money judgment, or if you get a money judgment through an eviction, you're going to have to go and collect on that money judgment on that tenant, which in and of itself is going to be another process. I can assist you with all that. I can help you navigate all that. The firm can help you navigate all that. You just need to reach out and let me know, and we can discuss what your options are. If the lease is expired, our landlord's going to be held to the lease rental rate. What other ways can a tenant be evicted other than using evictions via housing court? Let me answer these in pieces, Debbie. So if the lease is expired, is the landlord going to be held to the lease rental rate? Yes. I mean, we can make the argument before the court that you're entitled to, what would be a fair market value rate for that rental. But if there was a lease and it had just expired, it's going to be hard to, get the court to give us a judgment for anything other than what that monthly rate was, if that tenant is staying now past that lease. What other ways can a tenant be evicted other than using evictions via housing court? Ejectments, you can bring an ejectment action in Supreme Court. More costly, it's more time consuming, but it is an option. If you're interested in it, let me know. If you're a landlord that wants to take an extremely aggressive approach, it's an option. Let me know. We can discuss it. What has been, your experience with actual evictions post-COVID? My experience is that it's frustrating for landlords. I am very sympathetic to tenants who are facing significant difficulties. However, there are a lot of landlords out there who I know are frustrated because they might have tenants who have been taking advantage of the situation. If that's the case, it's very frustrating for a landlord. There are very few options that landlords can use aside from what I've laid out during the webinar. And then what is a procedure for a money judgment? Will it affect the tenant's credit? It will affect the tenant's credit. Bringing an action for a money judgment, you can bring a small claims action. If it's under $3,000 in small claims court, you can reach out to me about that. If it's over that limit, you'd have to bring it in Supreme Court, and that might be a more costly action. I think I have one more question, and then I'm going to wrap it up. What are your options when the judge does not rule a money judgment during an eviction? I mean, the judge is required to rule a money, to give you a money judgment if that's what you're asking for in eviction. If he doesn't do that, you're allowed to then bring an action for a money judgment, and I would suggest you do that. But if the judge does not give you a money judgment during an eviction and that you're owed that money judgment, that would be an issue. Again, reach out to me because you want to make sure that in the petition, in the paperwork you submit to the court, you make it clear that you're entitled to that money judgment. If you don't do that, you're not going to get the money you're owed. But if you do that, the judge should grant you the relief that you're entitled to, which is the money and an eviction. And so I think I've covered all the questions. I'm going to reiterate that everyone is entitled to a 15-minute consultation. Please don't hesitate to take advantage of that. I do have one more question. I can take a stab at that. Great info. Thank you very much. I really appreciate you all for participating. Again, we will have more in the future. Please keep in mind and don't hesitate to reach out. Thank you so much, everybody. Have a wonderful week. Have a wonderful night. I'm going to see there's one more question. You're welcome. Thank you guys so much. Be well. Stay safe, everybody. Thank you again.